Hello friends, welcome to Adusati, your partner in education. In this video, we will be discussing the concepts under constitutional law, and this is the first part of it. So let's start. The first concept we need to discuss is preamble. Preamble in a layman language would mean a preface to the book. Whenever we start a book, there is a preface which gives the basic structure to the book and explains what the book is all about. So preamble to our Constitution of India is the preface, and this is the bare wording of the preamble. So you can read it out. It says, "We the people of India," that is, it gives authority and power to the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, which is social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of individual and unity and integrity of the nation. In our Constitutional Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this constitution. By reading the bare wording of preamble, you would understand that it gives the authority and power to the people of India, that they are giving themselves the Constitution of India on 26th of November 1949, and this gives the basic structure and fundamentals of the Constitution of India by giving all these words of sovereign, socialist, secular, democratic republic, and the other rights of justice, liberty, equality, and further fraternity. Fraternity is brotherhood amongst the citizens of India. So there have been various debates about preamble under various cases as to whether preamble is a part of Constitution of India or not. So whenever there was any because some of the words under these five words were added after 42nd Amendment. So various cases came up that whether a person or Parliament of India can amend the Constitution of India or Preamble of India. So the next question that came into mind was whether it's a part of Constitution of India or not. So under various cases, and lastly by Keshwananda Bharati case, it was settled that preamble is very much a part of Constitution of India, and it gives the basic structure to the Constitution of India. So whenever any question of that kind comes, whether it's a part of Constitution of India or not, you can say that it's a part of Constitution of India as per recent cases. However, the debate still goes on, so you have to keep track of the recent cases coming up, if there is any major amendment or major case with regard to this question comes up or not. So for the time being, till now, it is a part of Constitution of India. Next is the concept of state. The article, whenever you read other acts and statutes, you would have seen that they provide for sections. However, the Constitution of India provides for articles. It does not provide for sections, it provides for articles. So Article 12 of the Constitution of India explains the concept of state. The word state herein refers to the whole India. It does not provide, if you think in a layman language, you would have understood that we have 29 states and it talks about one of those states. No, the word state here means India. It refers to India. So Article 12 provides, what does state include? The bare wording is this. It says the state includes government and the Parliament of India and the government and the legislature of each of the states and all the local and other authorities within the territory of India or under the control of government of India. So it's a very important and debatable topic. There have been various cases on these lines, that what are the authorities which come under the control of government of India. So as per cases and the bare wordings, this is the conclusive list which provides for the inclusions into the concept of state. First is the executive, that is government of Union of India and government of all the states. Next is legislature, that is Parliament and state legislatures. Okay. Next is local and other authorities within the territory of India. Next is local and other authorities under the control of executive, either union or state. One is authorities which are actually authorities under the state. This is under the control of executive. There are parameters which have been set as to how much control has to be there, as to how much control in terms of voting power or in terms of monetary terms, as to what would determine the control of executive. There are parameters as to that. So any local authority under the control of executive are also included in the concept of state. Judiciary is also included, however, other than judicial functions. Whenever judiciary is giving any judicial functions, that is passing judgments and all, in that case it would not form part of the government, because it acts free of any political and legislative or executive control. So working as per judicial functions, it would not be included into the concept of state, but otherwise as a body it is a part of state. Let's take a problem on this. Principle says state is not allowed to violate the fundamental rights of the citizens as enshrined in the constitution. So it says state is not allowed to violate the rights of its citizens. So the problem will be relating to the concept of state. Facts of the case are: Ravi Kumar was aggrieved by his dismissal from the government company he was working in. He challenged his dismissal before the state high court. For some reason, he was not able to appear before the court on the designated date. Consequently, the court dismissed his case for non-appearance, which is obvious. If you do not appear for your case, the case is bound to be dismissed. He challenged his dismissal before the Supreme Court. That dismissal by State High Court resulted in violation of his fundamental right, and since the State High Court is a constitutional body, it comes within the ambit of state, that is not allowed to violate the fundamental rights. So what we studied right now is judiciary is part of state. However, while giving its judicial functions, it does not form the part of state. So his case is straight away not maintainable because it does not come under the ambit of state. We just studied the components of state in the previous slide. So let's take the options. First is Ravi will succeed before the Supreme Court, as the High Court should have given him another opportunity to appear and should not have dismissed his case without listening to him. The clause of should has come, so the option is actually straight away taken away. It is not the right answer. We do not have to discuss whether it should be done or not. We just have to discuss whether the person would succeed or not. Ravi will succeed before the Supreme Court because State High Court is the constitutional body and therefore state. No, we already discussed that it's not a part of state. Ravi will fail because before the Supreme Court because State High Court, even though a constitutional body, is not state while discharging its judicial functions. So this might be the right answer. Let's take the last option. Ravi will fail because he was himself responsible for the dismissal of his case before the State High Court. No, this is the better option and the right justification behind his failure or behind the case of being not maintainable. So this is the right answer. Just to give you the idea, the only remedy Ravi has that he can approach the higher authority, higher court, with an appeal, not against the dismissal or not as a violation of his fundamental right, but he can actually go to Supreme Court with an appeal from High Court. So the better option available to him is appeal, not case against the High Court only. Next we discuss the Article 13. It's a very important article. It has to be discussed in parts. Law inconsistent with or in derogation of FR's fundamental rights. So it provides for the provisions that how laws would be treated which are inconsistent with or in derogation with fundamental rights. So what would happen to such laws which violate the inconsistent means which violate the fundamental rights and are not actually in consonance with the fundamental rights. First provision is Article 13 Clause 1 provides all laws in force in the territory of India immediately before the commencement of this constitution insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Right? So this term here, this part deals with the part which provides for fundamental rights. That's part 3 of the Constitution of India. So whenever this part is used, it refers to the fundamental rights. So it says that all the laws which are inconsistent with the fundamental rights shall be void to the extent of inconsistency. If a part of a law is inconsistent, that part would be treated void, not the whole law. Only to the extent of its inconsistency it would be termed void. Next clause is clause 2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. So it gives the direction to the state that you do not have to make any law which takes away fundamental rights or abridges, uh, which creates a halt between the enjoyment of the rights of the citizens. So any law made with relation to this part, this clause, would be void to the extent of contravention or the inconsistency. So the state is not allowed to make such laws which are inconsistent with the rights of the citizens. Clause 3 says, in this article, unless the context otherwise requires, it explains, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. So it provides what law would include. All these terms or all these parts are included in the extent of scope of law which are to be decided in the Article 13. Next is law in force include law passed or made by the legislature or any other competent authority in territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. So it provides what is the law in force. The basic term which need to be understood is the red text, that is law passed by legislature or any other competent authority before the commencement of Constitution of India. So this is the scope of law in force. Next clause is, nothing in this article shall apply to the amendment of this constitution made under Article 368. Article 368 provides for the powers given to the Parliament to amend the Constitution of India. So anything which is given under these three clauses, first three clauses, would not be applicable to the amendment made under the power of Article 368. However, this has been decided under various cases that Parliament cannot amend the basic structure of the Constitution of India. So the limitation has been put on the power given under Article 368 also. We will discuss Article 368 at a later stage. So basically, Article 13 is actually providing for the supremacy of fundamental rights, that fundamental rights are supreme and they have to be taken care of by Parliament as well as the judiciary. So any law which is not consistent and in consonance with the fundamental rights would either be void or it should not be made at all after the commencement of Constitution of India. So it provides for the supremacy and priority that is given to the fundamental rights in relation to all the other laws. Let's take the problem. Principle: the state shall not make any law which takes away or abridges the fundamental rights conferred in the Constitution, and any law made in contravention shall, to the extent of contravention, be void. The facts of the case are: the Supreme Court finds out that 8 sections of Bombay Prohibition Act to be ultra vires on the ground that they infringe the fundamental rights guaranteed under the Constitution. The term ultra vires is beyond the scope. So this is the this term is used for beyond the scope or beyond the powers given. So the Supreme Court has found that 8 sections of this act are not in consonance with the fundamental rights. So what is the validity of Bombay Prohibition Act? We discussed in the Article 13 that the law will be treated void to the extent of its inconsistency with the fundamental rights. So with regard to Bombay Prohibition Act, only 8 sections are not in consonance with fundamental rights. So the validity of Bombay Prohibition Act would remain valid, and only 8 sections would be treated void. So let's take the option. What is the right option? Only those 8 sections of Bombay Prohibition Act that are in contravention shall be held void. So this is the right option. Let's take the other options also. The entire Bombay Prohibition Act is void. No, only to the extent of its inconsistency the law would be treated void. So these are the only 8 sections, not whole act. Option C, for such matters the legislature should amend the Prohibition Act so as to remove the inconsistencies. That is the later stage. So for the time being, these 8 sections are void. D cannot be an option because we've already found the right answer. The right answer is only those 8 sections of Bombay Prohibition Act that are in contravention with fundamental rights shall be treated void. Let's start with the fundamental rights, and we will discuss the important fundamental rights. The first fundamental rights which is important to be discussed is Article 14, that is equality before law. You would see that in most of the cases which are related to the rights of the persons and citizens of India, everybody takes the plea of Article 14, 19 and 21. These 3 sections are related, and I'll tell you at later stage when we discuss all these 3 that how they are interconnected. These are basically taken together for the protection of the rights of a citizen. So I'll explain how these are connected. So let's start with Article 14. The bare wording says, the state shall not deny to any person equality before the law. First term that comes in is equality before the law, or the equal protection of the laws within the territory of India. So there are 2 terms used, equality before the law and the equal protection of laws. We will differentiate between these 2 terms for your clarity. Equality before law means everyone is equal before the law. It relates to administration of law. Whenever you make a law, every citizen has to be equal in the eyes of law. Nobody can be given preference on the basis of lame or invalid differentiations. For example, you cannot differentiate people on the basis of the caste, because you cannot give preference to some people on basis of race or color or something of that sort. So everyone has to be equal before the law. Next term is equal protection of laws, which means equality amongst equals. The like should be treated alike. The persons falling under the same category should be treated in a similar way. It relates to the creation of law. Whenever you create a law, the law should treat all the people falling in the single category similarly. No different right should be given to same people. Exceptions are the beneficial discrimination and affirmative action. In some cases, Article 14 can be exempted. Those exceptions are Article 15 Clause 4, which says special provisions for advancement of socially and educationally backwards scheduled castes and scheduled tribes. So in certain cases, when there is a requirement for the benefit of the society, that is beneficial discrimination, the benefit of the society, in that cases Article 14 cannot be pleaded, because in some cases the government provides special protection to the socially and educationally backward classes. In that case, Article 14 is not applicable, because that is in the nature of beneficial discrimination. Article 16 Clause 4, reservation of appointment or post in the favor of backward classes of citizens, that is in opinion of state, is not adequately represented in the services under the state. So this is also similar to beneficial discrimination or affirmative action, wherein the preference and reservation of posts is done in case of appointments. So the preference is given to such classes of citizens who are not adequately represented in the services, who do not get the chance to be appointed as those officers in general cases on the basis of their merit, or they are so educationally or socially backward that they're not given the opportunity to be there. So in those cases there can be a reservation. Article 16 clause 4a. Article 16 clause 4 extended to scheduled castes and tribes. Earlier it was only backward classes of citizens, so the scope of Article 16 clause 4 has been extended to scheduled castes and scheduled tribes by making amendment of Article 16 clause 4a. So everyone has to be treated equal before the law and everyone should be given similar protections, but there are exceptions to the Article 14 of our Constitution of India. Next article is Article 19, that is freedoms. So Article 19 provides for protection of certain rights regarding freedom of speech, etc. All citizens, the clause 1 starts, all citizens shall have the right, subclause 1, to freedom of speech and expression. All the politicians, whenever they say stuff against government or ruling government basically, so they are protected under the freedom of speech and expression. It's their point of view, so they have all the rights to express their expression in the way of speech. So this right is given to all the citizens of India until and unless you are defaming the other person. In that case it would not be a freedom. You have to have the freedom of speech and expression to give your thoughts, to express your thoughts, but it should not actually infringe the rights of other person. Next is to assemble peacefully without arms. You see all those peaceful protests and all, those protests are protected under the Article 19 clause 1 subclause 2, wherein you have the right to assemble peacefully without arms. Whenever arms are involved, in that case it is not protected. So any peaceful protest or march is protected under the fundamental rights, and you can actually express your thoughts and any kind of negative feeling against the government whenever you see anything wrong is happening. So people can actually assemble peacefully and express their disheartenment. Okay. Clause 3 says to form associations and unions. Everybody has right to form associations and unions like trade unions and all. These are protected under the fundamental freedoms. Clause 4 is to move freely throughout the territory of India. You do not require visas to go from one state to another. So that is protected under the fundamental rights. You can move anywhere within the territory of India without any kind of restriction by anybody. Clause 4 is to reside and settle in any part of territory of India. You have the right to live in any part of India. You can buy properties and live in any part of India. So that is also a protection given under Article 19. Clause 6 says to participate in any profession or to carry on any occupation, trade or business. That's right to profession. That is also given to you under the Article 19 of Constitution of India. These are the basic freedoms everyone would require in their daily life. You can relate to, while reading these freedoms, you can relate to all your freedoms. So every citizen must know what are their freedoms so as to enjoy the rights. Let's take a problem. All the citizens have right to freedom of speech and expression. Principle 2, whoever by words either spoken or intended to be read, or by scenes or by visible representations, makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person, is said, except in cases hereinafter expected, of defame the person. So this principle relates to defamation. First is the principle of freedom of speech and expression, and the another principle that is given to you is that of defamation. So this problem relates, definitely goes in between the defamation and freedom of speech and expression. So let's take the facts. On the occasion of Law Day, the Chief Justice of India in his speech says, "These days it is very easy to buy judges. Mr. Justice D.S. Sadhu was accused of corruption and his case was pending before the court of law. Mr. Justice D.S. Sadhu files a defamation suit against the CJI, that is Chief Justice of India, on account of his speech. Will Mr. Justice D.S. Sadhu succeed? So, taking both the principles, the speech given by CGI says these days it's very easy to buy judges. It in no ways can actually imply that that he intended to target Justice D.S. Sadhu in relation to his corruption case. So he cannot actually take the CGI to the court by claiming that he has been defamed. So the person that is CGI is protected under this principle, that is right to freedom of speech and expression. He just expressed his view that in these days it's very easy to buy judges. He did not mean to defame any person, because the lines which are given in his speech nowhere target on any single person. So let's take the option as to whether he will succeed or not. For option A, CGI is liable as his words were defamatory in nature. No, it was a general statement that was given by him, not intending to target anybody. So it cannot be a defamation because it's not in relation to single person. Next is CGI is not liable as his words are protected under freedom of expression. So this can be an answer because his words are protected under first principle given to us. C. CGI is not liable as his words were not directed to Mr. Justice D.S. Sadhu but was a statement made on an entire judiciary. Yes, it's a general statement, so this can also be an answer. So we have two answers, and that the D options comes out to be true because it provides for both B and C. So the right answer is D. That is, first reason is that his words are protected under freedom of expression. Second is the words were not directed towards single person. It was a general statement made on entire judiciary. So it's not the case of defamation. Under Article 19, there are certain reasonable restrictions that has been put. So your freedoms are not absolute. You have certain restrictions which are being put on the freedoms, and these are reasonable restrictions. So how do you determine that it's a reasonable restriction? So these are the parameters which will help you to understand whether the restriction is reasonable or not. First is the restriction absolute or is it partial? If it's absolute, then it's not a reasonable one. If it's a partial restriction and you are it's just that the state actually intends to protect the rights of others, so your right is restricted partially so that you enjoy your right, taking into consideration the rights of other person. So it does not have to be absolute but partial. Next is, what is the purpose of government is trying to achieve through the restriction? Is it in public or national interest? If the restriction is for public and national interest, then it's a reasonable restriction. You cannot be allowed to do anything if it's not in consonance with the public or national interest. You cannot do anything against the sovereignty of India. So any restriction put on your rights to protect the sovereignty of India would be reasonable restriction. Was there any other way of achieving that purpose, or was putting a restriction on the fundamental right was only way? If there is any other way other than putting the restriction on fundamental rights, then it would not be reasonable restriction. So if there is only the way which is available to the state is putting a restriction on the fundamental right, so in that case it would be termed as a reasonable restriction. So Article 19 Clause B, grounds for reasonable restriction. So what are the grounds on which a restriction can be put on the fundamental rights? First is security of the state, friendly relations with the foreign states, public order, decency and morality, contempt of court, defamation, incitement to an offence, sovereignty and integrity of India. So these are the grounds which will determine whether the restriction is reasonable or not. On these grounds, state can put restrictions on the freedoms which we discussed in the 19 clause 1 clause A, right? So These are the restrictions on your rights. Next is Article 20, protection in respect of conviction of offences. It's a very important one. All the fundamental rights are important. You just need to understand the basic concept so that you can solve the problems in exam. So let's take clause 1. It provides protection against ex post facto laws. Let's understand what is ex post facto law. A law that imposes a penalty retroactively or increases the penalty for past acts. Retroactively means that you have done certain crime 2 years back, and at that time it was not a crime because there was no law which termed it as to be a crime. If government has passed a law today, you cannot be punished under that law for the acts done 2 years before. So or even if the penalty for the crime has been increased today, so in that case you cannot be given the increased penalty. The person is only convicted and given penalty for the for under the law which was prevalent at the time of the act or the crime, not any law passed after that. So let's understand the bare wording. No person shall be convicted of an offence except for the violation of law in force at the time of commission of the act. So violation of the law in force at the time of commission of the act, charged as an offence, nor be subjected to penalty greater than that which might have been inflicted under the law in force at the time of the commission of offence. So it says you cannot be given greater penalty than which is under the law which is prevalent when you committed the act which is an offense. So you cannot be given more penalty, or you cannot be convicted at the later stage after passing the new law. So any act done under, for example, if today in 2015, this is a hypothetical situation, killing somebody, or suppose killing any animal is not a crime. Just an example, if in 2015 killing any animal is not a crime, if at a later stage in 2016 such law is passed as to convert it into a crime, that killing that particular animal would be crime after 2016. So if you had killed that animal in 2015, you cannot be convicted under the law which was passed in 2016. So this is the basic fundamental nature of the clause 1, that is protection against the ex post facto laws. Article 20 clause 1 only prohibits the conviction and sentencing under ex post facto laws, but does not say that ex post facto law is itself valid. So this means the law passed in 2016 is not valid. It's just that you cannot convict people who had done act prior to 2016 as to in relation to the act and its powers. So the law would not be invalid, but the conviction of person for the previous acts would be invalid. Next clause is protection against double jeopardy. Double jeopardy is nemo debet bis vexari, that no person cannot be prosecuted for the same offence more than once. Double jeopardy, or this term, means that you cannot be convicted for one crime twice. That if you had killed that animal, you would not be given punishment twice under the different codes or under the same code. So it's called double jeopardy. A man must be put in peril twice for the same offence. If person is prosecuted and acquitted, then he cannot be prosecuted on the same offence again. It says if you are prosecuted and then acquitted by the court, you cannot be prosecuted on the same offence again. So that would mean that if somebody takes you to the court and you are acquitted by the court on the offence, the same person cannot approach any other court on the grounds of same offence, and you cannot be prosecuted on the basis of same offence because you were acquitted. That is, you were given clean chit by the acquittal, means you were given clean chit by the court. You were held not guilty. Last is clause 3 says protection against self-incrimination. Self-incrimination is giving witness against himself. So no person accused of any offence shall be compelled to be witness against himself. Parallel provisions must be put in Indian Evidence Act and Criminal Procedure Code. The protection given under Article 20 Clause 3 says that you cannot be asked to give evidence against yourself. If you are forced to give that evidence or statement, that would be invalid. So this line says that similar provisions should be given under Indian Evidence Act and the Criminal Procedure Codes also. So till now the only protection given is under 20 clause 3. So it says that the state shall make efforts to put similar provisions in Indian Evidence Act and Criminal Procedure Codes to give better coverage and to give the better scope to the concept of self-incrimination. So any case of police forcing a person to give statement against himself is covered under the clause 3 of the Article 20, and that is invalid. Let's take a problem on that. Principle: no person accused of an offence shall be compelled to be a witness against himself. Explanation: we've already discussed. Facts are: Ronnie was a member of a criminal gang that was notorious for kidnapping and ransom. One day, police laid down a trap and Ronnie was arrested. In the police station, Inspector Chulbul Pandey beat him black and blue. To save his life, Ronnie confessed to all the crimes that he had committed, and even those that he had not committed. So he confessed under the threat of Chulbul Pandey to save his life. So it was not a free confession, right? Based on the confession, the court convicted Ronnie. Now he challenged his conviction before the State High Court on the ground that his confession was forced. Will he succeed? Applying the principle, it's a clear case of self-incrimination, so he will succeed because he was forced and he was beaten badly by Inspector Chulbul Pandey. So to save his life, he confessed all the crimes and all other crimes which he had not committed, right? So this is a forced confession and it's a self-incrimination case, so he will succeed under Article 20 Clause 3. Let's take the options. Ronnie will succeed because Inspector Chulbul Pandey is known for giving his prisoners third degree. No, this is not the criteria. Next is, Ronnie will succeed because the confession on which his conviction is based was forced out of him against his will by use of force by the police. Yes, this can be an answer. Ronnie will succeed because there is no evidence that he's actually committed any kidnapping or has demanded any ransom. No, this is not the answer. D. Ronnie will fail because Inspector Chulbul Pandey is very popular and honest police officer. This is also a very lame option given. So the only option and right option left out is that he will succeed because it was a forced confession and it's a case of self-incrimination which is not allowed in India. So this is the right answer. Next very important article is protection of life and personal liberty. The bare wording says no person shall be deprived of his life and personal liberty except according to the procedure established by law. It's a very, very wide article and the scope of these terms, these bare wording has been extended to almost every aspect of your life. When you talk about living with dignity and deprived of his life and personal liberty, it actually extends this right to life. The name which is given to this article is right to life. It extends the right to life to living the life with dignity. So this has been interpreted by the courts of India very extensively, and this has been applied by courts in various cases and various ways. So not only there should be the law, but the law must be fair and reasonable. One of the cases and by the Apex Court of India, that is Supreme Court, has settled that wherever there is a law, it must be just and reasonable. Anything which is unfair and reasonable would actually amount to violation of Article 21. Next, I had told you that Article 14, 19 and 21 are connected. So whenever any person is approaching the court for protection of his rights, that person actually takes the plea of all these three articles together. Article 14 relates to the equality before law. 19 is freedom. Whenever any case comes up, it would come under one of the freedoms by one way or the other. Next is Article 21, which actually applies to almost every aspect of your life. Anything unreasonable done to you actually comes under the scope of Article 21, because it is covered under Article under your right to life. So whenever you approach court, these three articles can be applied simultaneously, and these are actually based on the principles of natural law. So the articles are taken together, and these are very well connected. So the relief is given in a better way if these are all three articles are taken. Personal liberty in Article 21 was to be given widest amplitude. As I already told you, that the terms used under Article 21 has been interpreted extensively by the courts of India, even the Supreme Court of India. So they are given widest amplitude. That means the explanation which is given to this article is very wide. You would see like thousands of cases and thousands of areas where the protection of Article 21 has been extended. Article 20 and 21 cannot be suspended during emergency. These are the articles which will remain in force. Everybody would have right to life and protection against the conviction in case of offences in all the cases, even in the cases of emergency, and these cannot be suspended. Article 21, that is right to life, is available to the foreign citizens as well. All the rights under the Constitution of India are not available to foreign citizens. So Article 21 is the one of the rights which is available to foreign citizens, that is right to life, for obvious reasons, because everybody has a right to life. Let's take a problem. No person shall be deprived of his life and liberty except by the procedure established by law. Let's take the facts. A is a patient with AIDS. He seeks treatment from a government hospital. Unfortunately, the nurses and doctors there spread the news of his affliction, and he suffers much discrimination and prejudice. He sues the government for violation of the right to life. Let's take the options. A is not being killed by government. How is the right to life being violated? As I told you, the right to life has a very wide scope, so this is not the option. Just because that person is not being killed, it does not mean that it would not be the protection under right to life. B, A's right to life includes right to life with dignity. Like I already told you, dignity and respect. This is the clearly violated here. So yes, this can be an answer. Your right to life actually includes right to live with dignity and respect. So in this case, by revealing his medical condition to other people, the government hospital has actually violated his right to life. It is important for others' liberty that they get to know about the person suffering from such dangerous communicable disease, so that they do not suffer the same. Hence, it's implied within the procedures of established under the law. No, this is not the answer. There is no procedure that is being established by law which provides for giving the personal medical condition information to the other people. So it's not the right answer. B, A's right to life is violated because he is already suffering and doctors and nurses have no right to add to his miseries. No, this is not the right justification. The only justification which is right to his succeeding is that A's right to life include right to life with dignity and respect. So it's a violation under this case. So this is the right answer. So continue to watch the next part. I will discuss all the rest of the parts under constitutional law in the next part. Thank you.